look, all this came about because apparently the gentleman didn't make a full declaration in his assets. I think that has been established somewhat. So what do you think of that action in the first instance?
I think that the Chief Justice of Nigeria is the primary and principal repository of the system of justice in Nigeria.
Okay.
I think that for the Chief Justice, more than any other judge, he must be beyond suspicion. I think that the integrity and effectiveness of the system of justice and the rule of law depends on the quality and character of the people who sit in the seat of justice. I think, therefore, that anybody occupying that seat has a responsibility beyond himself to that seat and to the system of justice, and this is the principle upon which such an individual should be guided.
Now, do you think the government has then gone about this in the proper manner? Do you think there's any political undertone to this?
There's in any of the affairs of state, there must be political undertones.
Yeah.
I don't know what those are here. I don't know what the details are. But to take on the head of a principal arm of government must be a seismic social and political event, and one which should not have been undertaken without a strategic consideration of what needed to be done and how it should have been carried out. This is something, if the Chief Justice of Nigeria was caught with a blood-stained dagger, I would expect the highest political authority to consider how to deal with the ramifications of that beyond the law. So that's very
beyond
important.
The law.
Absolutely.
Okay, but have they done it according to the law in the first instance?
Well, that's a matter that is going to be debated and discussed in several fora. What I can say is that the Constitution creates in the judicial office a special character of employment. In the office of the Chief Justice, the Constitution makes great efforts to protect it from interference by the executive, and it does this by creating a complicated process for removing the Chief Justice. That process has not been followed.
Okay.
But beyond that, will be in the operation of any law, you have to consider what is the purpose and what is the threat. And I think it may be fair to say that if there is a sufficiently significant threat to the rule of law, to the system of justice, that it may be possible to justify exceptional action.
To justify exceptional action?
Yes.
That's what it said?
Yes.
What does that mean?
Well, exceptional action could be a variety of things.
You mean going beyond the norm?
Absolutely. I think that one of the truisms which I learned when I started studying law was that in constitutional law, nothing succeeds like success. For example, when the question of the appointment of an acting president without the transmission of a letter from President Moriadua became a legal issue, it was resolved that by what they then called the doctrine of necessity. Now, this is not a new doctrine. This is a doctrine that's been applied in Pakistan, Australia. What is the essence of that doctrine? If a situation, political, legal, social, arises which is not directly within the contemplation of the Constitution, or which the Constitution has not met, then there becomes an imperative to deal with that situation nonetheless. Now, as to whether the removal of this Chief Justice is such an emergency is a matter for someone else to decide, having reviewed the facts. But at the very least, I would hold the view that if a Chief Justice is under suspicion and the processes by which he can be regulated and held to account are in his control, and then that would be an exceptional situation. And in deciding how to deal with that exceptional situation, you would have to balance a variety of interests: political, legal, social. And my personal view is that if the seat of justice is defiled in such an exemplary way, I'm not saying necessarily that on the merits of this case that happens here, but if that situation arose, then in my opinion, this would be an exception bordering on an emergency. Public confidence is threatened, the rule of law cannot be effective. If the seat of justice is polluted, nobody can have confidence in operating. That, in my opinion, would be a threat to the rule of law.
So you think that's why the government took this route?
I don't know why the government took the route. They must
Yeah,
have their own decisions.
But it will add up, wouldn't it?
Well, we can speculate.
We can speculate, yeah.
Yes, not being privy to the thinking of the government. Certainly, I would have, if I was operating this system, I would have considered it to be an emergency, but I would have considered perhaps more deeply the tactics and strategy of defending the Constitution against this danger.
But the ultimate aim is to remove the moat, is to take the man out, really, to put it bluntly in street language. And he's out, as it were, because even if he doesn't resign and he stretches this case for as long as he wants, I don't think he's going to become a America's CJ. Is that likely?
It's not the first time, either here or across the world, that a principal officer has had to vacate office, notwithstanding that the legal process may well not have been most effective. I mean, people as old as myself can remember that for whatever political reason it was, that Justice Tassim Elias left office on grounds of ill health. Well, that's whatever may have been the contest there, and I'm not sure what it was, that was one way of moving an individual aside. In other countries as well, the Chief Justice is a political actor. Political actors step aside on family grounds, on health grounds, so they can study, so they can walk the mountains. There are a variety of reasons to write books. And you have to decide in any situation what is best for the institution. This institution of the judicature is so fundamental to the organization of our society and our environment that it must be unblemished. This is of primary importance, in my opinion.
Well, let me even ask, now that I have a son with me, I've asked so many of them, if I'm supposed to fill a form, a statutory form, and I then forget, quote and unquote, forget to add certain things, code of conduct form, I forget to add some of my assets. Is that admissible? Is ignorance? No, that's not ignorance. Really, it's forgetting. Is that admissible? Is that kind of defense admissible? Saying you forgot. I mean, if, for example, I work for the government, and let me see, what kind of situation can I look at now? I draw money from the treasury. I'm supposed to return it by a particular time, and then 2 years later, I say I forgot to return the money. Is that acceptable?
First of all, we should think about the rules that apply to ordinary people, and then think about how acutely they must apply to people holding high legal judicial office. If you arrived at the airport in London and failed to declare something in your luggage, how quickly do you think you'd be handcuffed?
You can say that again.
That's the law.
Yeah.
If you drove down the wrong side of the road because you thought you were in Lagos when you were in London, how quickly do you think you'd be arrested?
Yeah.
So in ordinary day-to-day activity, we all recognize the truism of the law that ignorance is not an excuse, forgetfulness is not an excuse. And when you consider the significance of what has been forgotten, you have to consider how likely it is that this was an error of memory. So you have to bear these circumstances in mind. And then I go back to the point I made earlier on about what is the responsibility to the office and to the judicature. Is it in the interest of the judiciary for us to be having this discussion as to whether it was forgetfulness or concealment? Does it not put a principal office of state under unwarranted suspicion? Is this in the interest of the rule of law? If the man on the street cannot have confidence beyond doubt that the testimony and the recollection of a principal judicial officer is unimpeachable. This is a problem.
So in your view, whatever the circumstance, I believe you believe Olonye should have quit office.
You know, if
as a matter of honor,
yes,
if anything.
Sure. You know, if a judge was caught having sex in a public place, which may not be legal, is it consistent with the dignity of his office to remain in office?
But it's illegal to have sex in
Okay.
public place.
Maybe it's not illegal to have sex in other circumstances. My expertise on public sex is not very high.
Neither is mine. Yeah, okay, go on. I got the point.
So this is the point. You have to have, when you hold an office, you have to bear responsibility.
Yes, you do have.
And it's, I think most people know that the higher your responsibility, the higher your duty. You cannot and holding high office say that what you might excuse your driver for, you would excuse yourself for. The code of conduct for public officers is a constitutional requirement. I cannot ask a judge in the High Court to tell me they forgot their responsibility under the law that they swore to administer.
Why then do you think it has been, taking this man so long to cave in and do the right thing? He's been running from one court to the other, trying to get adjournment and things like that. What does that tell you about the practice of law in this country? Because, I mean, hey, if he's at the apex, and of course what makes the whole scenario worse for lawyers now as we speak, is that even the president of the NBA himself is on trial in another case entirely. But so it puts the law under the spotlight.
Yes, I think that the fact of an indictment of the Chief Justice as president of the NBA are themselves matters which those individuals should consider in respect to the offices they hold. But you referred to, as you put it, running from place to place, seeking adjournments, etc. The behavior, even after, can be disqualifying. Because it seems to me that you cannot be the center of judicial activity in Nigeria and broadcast by your behavior to the public that you do not have confidence in the system of justice in Nigeria. The place to prove innocence is in a trial. That's what the judges tell everybody. And they're right. So the behavior of evading the process of accountability is in itself disqualifying.
And embarrassing.
I think it is.
It must be, I mean, hey.
Yes.
The law is under the spotlight.
This is true.
The law profession is under the spotlight.
This is true.
And I'm sure that's why 19 of you got together. What exactly do you plan to do?
Well, the first thing we wanted to do was to lay down a marker. Senior advocates of Nigeria are statutorily leaders of the legal profession. It's a brand of leadership, and we have to live up to the brand. So we wanted to make it clear that at least some of us, and I have no doubt there are more than this 20. You get together the people that are close by to you and say, look, something is going on, we need to stand up, and you have to stand up from somewhere. And you needed to make it clear that we recognize there was a problem. We recognize it's our responsibility. We recognize that the rule of law is fundamental and that legal practice is fundamental to the rule of law, which is a service delivered to the public and one for which we are accountable to the public. And that many things which have been done or undone in the last 30 years, maybe even, have not delivered to the public. And we have been regulating ourselves because we're permitted to do so by the public. If a profession cannot deliver value to the public, it has no right to the privilege of self-regulation. So the regulation of our profession by ourselves is only justified if it is of value to the public. If the public loses confidence in the legal system and legal practice and lawyers, then we have undermined our right to exist. And this is what we are telling our colleagues.
Colleagues, yeah.
Guys, this train is going to hell. We need to stop it. And it's not something that 20 people can stop. It's not something that 20 SANs or 20 judges can stop. It's something that somebody just needs to blow the whistle and say, we need to do something about it. And we shouldn't be afraid of the consequences of telling the truth. Two things that are very important, in my opinion. In any circumstance where you have public responsibility to tell the truth and to do your best.
What kind of support have you gotten from your colleagues on this? Because I must say, the perception, now I choose my words carefully because I'm sitting in front of a lawyer. I'm so terrified of lawyers, even though my dad was one.
I'm a teddy bear.
I don't know, they're not a teddy bear. She might think that. She might think that they're teddy bear. I don't think so. That was a joke. That was a joke. Now, because, you know, how have your colleagues reacted to all this? Because there's a perception from most of us on the outside that there's some rotten eggs that are affecting the whole bad lot. You must admit that there's some rotten eggs. Like in my profession in the media, for example, loads of rotten eggs. I must admit that. We're trying to see how we can do that. But in your case, what kind of cooperation are you getting? You see, because unfortunately there are some of your colleagues who they've made their name out there and have not stood up to be counted at a time like this. So how are you going to balance all that out now?
Well, you have to make statements which are unimpeachable, which are values-based, which can't be contested. It's difficult to contest facts which are in the public domain. The events we related in the statement we made. It's difficult to contest the responsibility of legal practitioners to the integrity of the judicial system. It's difficult to contest that bribery and corruption is a poison in the system of justice, and that it has been infiltrated by cooperation between some judges and some lawyers at the highest level of practice. We said so in the statement, and this is the truth. When you talk about the truth, people often say, many people say, but I know many examples. I've seen the operation of this sort of behavior. And when you build a system on criminal activity, which is what this is, there will always be beneficiaries. And those beneficiaries make an order out of that system. Like the mafia, I guess. The mafia has regulation, it has codes of conduct, it has captains, it has lieutenants, it has foot soldiers.
And capoons, I think.
Exactly. So, if you recognize that the problem of justice is that there is some criminal activity and criminal conspiracy, then you have to recognize that not everybody, because some people will benefit from that system, and not everybody will want the system to be dismantled. So the question for us is this. If this system is inconsistent with our values, should we be silent? No. If this system is not valuable or is indeed destructive of public trust in the system of justice, which is essentially a resource for the public, should the public not reject it? If they do, then we have an important ally. I think that the ultimate auditor of what people do in their professions is the public. So the question now is whether an alliance between people who want to do the right thing and members of the public who are the users of the service, and the high number of right-thinking, upright, upstanding members of the judiciary, and there are numerous judges who have spoken, even in the last, you're talking about reaction, in the last couple of days, people who have called, judges who have said, you know, thank you for what is being done, we have been despondent, some of us have considered resigning, the things that are going on, it's not what we came here for, we came here to apply law, we came here to advance justice, there are all sorts of things. Sometimes there are so many ways in which a judge who wants to do right can be diminished, deflected, pushed aside. It happens all the time. And the profession knows who are the judges who, I think Femi Falana said that in a statement recently, they know who are the judges who are corrupt, and they know the judges who are not. Okay. You cannot allow the bad wants to spoil the entire audience.
Yeah. Okay, we need to take a shot. I need to pay some bills here. I need money. We need to run a commercial.
Not only you.
We take a short commercial break. When we come back, I'll start taking your calls and your reactions on Twitter and so on and so forth. We'll be back. So how are you doing?
I'm fine, thanks.
Nice to meet you.
It's a great pleasure. Thank you.
Yeah.
Do you have 2 minutes to use the toilet?
Oh yeah. Let's finish.